Thank you, Mr. Johnson. I'll begin our first round of questioning. Mr. Johnson, if I might, just to pick up from there, your written testimony points to the Supreme Court's caution in the Alice and Mayo decisions that interpreting its exclusionary principle too broadly could eviscerate patent law, because all inventions at some level may embody or apply natural phenomena, laws of nature, or abstract ideas. How have our courts done at applying the exclusionary principle?
Well, very inconsistently, and unfortunately, I think they have interpreted the Supreme Court decisions in a way which has caused them to overly find ineligibility of deserving inventions. And I pointed to a number of these, but some of them are so plainly unpredictable, things like automotive transmissions and other things that have traditionally been patentable for a very long time, including and some of the things that bear on diagnostics and medicines, such as naturally occurring materials, which are, of course, not patentable when they exist as they are in nature, but which very often are the basis for very important inventions and medicines. And I think I cite to Sherry Knoll's testimony, which provided an extensive list of naturally based drugs. And unfortunately, if you look at the approvals, you'll see the approvals for these kinds of drugs, for one reason or another, dropped off starting about the same time as the Supreme Court cases.
Thank you, Mr. Johnson. I agree with you that the law of ineligibility is indeed a mess, but that is the purpose of our hearing today, is to try and make progress on that. Ms. Brinkerhoff, have the courts applied eligibility law more predictably since our 2019 hearings on the state of patent eligibility? Have they made any significant progress since the constructive and insightful guidelines that were promulgated by the former PTO director?
The short answer is no, except the only predictability that we have is that diagnostic methods are not patentable, but that's not the kind of predictability that we want when we believe that patents promote investment and innovation in these important industries. Literally every time a new decision comes out on 101, we read it with trepidation to see how it's going to be applied in an inconsistent or new way. And I think the cases that I mentioned on digital cameras of all things or physical devices of all things show that even the Federal Circuit isn't applying the exceptions in a consistent manner.
Some have argued that current eligibility law is sufficient because although natural products aren't patent eligible, methods of using natural products are still eligible for patenting. Do you agree? Why or why not?
So I disagree, because when the inventor is the first person who's discovered the substance and determined its usefulness, a patent on a specific method of use is not going to reflect or reward the contribution that that person has made. When your patent only covers a specific method, it's difficult to detect infringement and enforce your patent against others, even the limited rights that you have. You can't stop others from selling the product, so you have to police labeling, packaging, marketing materials to see if your patent is being infringed. And for process patents, it can be even more difficult to detect if your process was used. And there's also a number of practical and legal reasons why it can be challenging to obtain specific scope of method claim protection, which actually brings in some of the 112 issues.
Mr. Blaylock, you've testified PARA would impose effectively no limits on the patenting of genes and other natural materials. What about the other sections of the Patent Act, 102, 103, addressing novelty, non-obviousness, and the like, as Mr. Johnson suggested? Wouldn't those finer filters to patentability work to avoid the harms that you flagged in your testimony?
No, Senator, they would not. This is the reason why I concentrated on the concept of biomarkers. These are the biomarkers I'm talking about are being discovered every day. They are therefore new and non-obvious, and it is easy to describe them and how to enable someone to use them, and even to describe the best mode for their implementation. So So the rest of the requirements for patentability are real and important to the patent system, but they do not address the concern that PARA would change the current environment and make the patenting of information, of knowledge about an association between a particular genetic anomaly and its clinical significance. Because what would be patented would be merely the use of conventional everyday techniques such as Illumina's-based next-generation sequencing or old-style Sanger sequencing in order to detect that information. It is, so in short, unfortunately, PARA would make a dramatic change.
Mr. Iancu, do you agree with Mr. Blaylock's assessment of PARA? Do you think we need additional legislative language to keep patentability requirements separate, or is that already implied in existing law? Would it have the impact that he's predicting?
No, I disagree with him on that. I think it's PIRA addresses the fact that the pure natural product itself, and the statute says, quote, as such, is not eligible. It's one of the exclusions. As soon as that is applied by human hand and human ingenuity to a practical application, such as diagnosing in a diagnostic kit a particular disease, that is human innovation, and that should be eligible. Whether it's patentable, then we need to decide whether it overcomes novelty and obviousness vis-a-vis the prior art. But it's really important to understand the fundamental concept of what human invention is. All human invention, all of it, is the manipulation of nature towards practical uses by humans on this planet. So we can exclude nature itself, but any human intervention and manipulation, that is what human innovation and engineering is, and that should be eligible for patent. It's the useful arts under the Constitution, and then we can apply the fine filters of 102, 103, 112.
Thank you. Thank you all. Senator Tillis.
Mr. Blaylock.